I wanted to find out you didn't put the deposit into escrow, right?
That's
a
exactly what I
buyer.
did. That exactly
That's
what I
a
did.
mistake.
The buyer wrote a check, which I drove to the escrow, very professional, very high-end escrow company, and I gave them the check, and they made the copy, and they even, well, I didn't realize that escrow people do. I guess very very nice option is they even faxed or emailed the scanned contract to the listing agent, to the broker, and it was very nice, and I was expecting everything to be great. So yeah, we gave the money to the escrow lawyer. I did it myself.
Well, anyway, I had a situation where the buyer got cold feet and we were in escrow closing in about 5 days. The buyers all of a sudden just decided they didn't want to do it by text also. And I think, is that right, Tanya, that we have a claim to the funds within the that was deposited in escrow? The seller does, because they owe the brokerage fees, right? They also owe escrow fees, and they have also incurred some expenses, relying on the fact that that contract was going to close 5 days later. Is that
Right. So it depends on what state you're in. So Dennis is in Florida, and where are you?
California?
California. So here in California, we use escrow companies exclusively. We don't use closing attorneys typically. Uh,
Oh,
but in Florida, East Coast,
mm,
all that, they use closing attorneys to handle their transactions.
mhm.
So it's a little bit different of a process. But and typically, though, to your question, if you're 5 days away from closing, does the seller have a right to the buyer's deposit? Well, it depends. If you, as the broker, had or if the buyer's broker, um,
Buyer didn't have a broker, so it was a
okay,
seller. Yeah.
all right. So if the buyer waived their contingencies, because
Mhm.
the contracts in California, if you're using cab forms, have various contingencies. So you get a lease contingency, a due diligence contingency, financing, might be other contingencies like a franchisor approval or something like that. Once those contingencies are waived, the
Mhm.
buyer's deposit is at risk.
Mm.
And it's an active removal. So just because the contract says you're gonna, you have 30 days to get a lease approval, if the buyer has not signed a contingency removal or waiver, um, waiving that lease contingency, then it still exists. And so literally you can have contingencies out there that still exist till the very day of closing.
Yeah. All
And so
contingencies.
it just depends, because the buyer's funds are not at risk as long as there are contingencies that are still out there operating.
Mm. Yeah, but all the contingencies were signed off on and the lease was signed, so
Yeah, so at that point, the buyer's deposit um, can go to the seller and the broker
right. And
per
do
the
you know
terms of the contract.
what that process looks like? I mean, I'm in communication back and forth with the buyer's attorney. All of a sudden they have an attorney. Um, and yeah, what does that process look like? I mean, he's saying list all of the costs incurred. So do I submit it
So
to escrow?
no, escrow basically, according to the terms of the contract, so if the buyer's deposit is sitting in escrow, escrow is not going to release those funds without a specific escrow instruction stating who those funds go to. What I would do is look at the actual terms of the purchase agreement. There's a liquidated damages clause in there. If all
Mhm.
of the buyers, if all of the buyer's contingencies had been waived, then they're in default of the contract, and the liquidated damages provision should kick in. And so that dictates where those funds go. And then I would just, you give that, you tell escrow,
Mm.
draw up an instruction consistent with the liquidated damages. Now, they'll do that, but understand escrow works for buyer and seller, not for the broker. right? But broker is a party to the
Correct.
agreement as
Right.
to certain provisions. So just because escrow draws up a release of funds in a way that's consistent with the liquidated damages provision doesn't mean that buyer and seller are going to sign it. And
Right.
so escrow will sit on the funds and not hold them until they have signatures from both buyer and seller. If one or the other party refuses to sign, then at some point escrow is going to turn around and file an interpleader with the court and send that deposit to court and let the parties work it out in court. So
Okay.
that's the process in a nutshell.
Okay.